Hello friends, this is me Nakshatra with a new topic on professional ethics of advocate. In the previous video we have already covered the topics on the duties of advocate to his client, to his opponent and to his colleagues. And today in this video we are going to see what are the duties of an advocate to the court. Advocacy is a noble profession. It is also a public service. Hence it is the most honorable profession in the society. An advocate has several duties to his client, to the court, and to his profession and even outsiders. The client prefers an advocate who strictly adheres the 8 lamps of advocacy. The client trusts the workmanship of an advocate. He sees how hardworking, how sincere and how dedicated the advocate is, and they also prefer an advocate whom they can easily reach and who can explain their difficulties. An advocate must always possess the duty consciousness. Client usually likes the advocate who is sincere, who is dedicated and who devotes his entire time and energy for his client. So the duty consciousness of a lawyer is very important, and once his engagement is final, then he sticks to the preparation of the case on the fact and the laws in such a way, in such a tendency that he leaves no effort from his side to win the case in merit. Whether the client is present or not, the advocate must pick up his particular file and at his leisure, which requires his further attention, and he should make some more preparation in the view of the instruction which he have already received from his client. And if the advocate is not still satisfied, he have to take down some more special detailed notes through which he can win the case. And the temper of the advocate is very important, because ill-temperedness in a lawyer is a serious drawback to his personal character and also his professional development. The Bar Council of India has made certain rules so as to prescribe duties of an advocate to the court. Rule number 1 says that an advocate shall, during the presentation of his case and while otherwise acting before the court, conduct himself with dignity and self-respect. So it is the duty of an advocate to maintain his dignity. He have to maintain his respect towards the court. Whether he is representing in the court in his case or he is in the court, he might be a spectator, he might be an audience in the court watching the proceedings. Anyways, so whenever an advocate is inside the court, it is his duty to maintain the dignity. He shall not be servile, and whenever there is proper ground of serious complaint, a judicial officer, it shall be his right and duty to submit his grievance to proper authorities. So when there is any complaint, when there is a serious complaint, it is also the duty of the advocate to submit his grievance. Rule number 2 says, an advocate shall maintain towards the court's respectful attitude, bearing in mind that the dignity of the judicial office is essential for the survival of a free community. So the advocate should maintain his respectful attitude. He is not supposed to shout in the court, he is not supposed to use scandalous words, or he cannot behave in any improper manner, because this will definitely spoil the dignity of the court. The court is a place where people, they come seeking for justice. So when an advocate behaves in a manner which will reduce the dignity of the court, the normal civilian, they will also lose hope in the judicial proceedings. Hence it is the duty of an advocate to maintain a respectful attitude in the court. Rule number 3 says that an advocate shall not influence the decision of the court by any legal or improper means of private communication with the judge relating to the pending case are forbidden. So an advocate, he cannot influence in the judge's decision. So whatever decision is given by the judge, that is final. So he cannot influence, or he cannot meet the judge in person and make some communication with the judge to give the judgment in his favor. So this kind of things are forbidden. So an advocate cannot interfere or he cannot influence in the decision of the court. The 4th rule says that an advocate can use his best effort to win the case, but he cannot do any unfair practice, and he also should educate his client. He should tell his client and he should educate him like how he should behave in the client, how he should behave with the opponent counsel, the opposite party. They cannot shout at the opposite parties or at the opposite counsel, which even the advocate cannot do. So he should educate the client that he should not do such things in the court. And the advocate, he must not be the mouthpiece of the client. So whatever the client says, he just memorizes those things, and he should not come and omit all those things in the court. He should not be the mouthpiece of the client. So he should tell the client with what are the possibilities, what are the procedures, and the court will function only according to that. So if there is anything they have to do, they have to go according to the pleading, and especially they have to maintain the language. The language is which they use is also very important during the course of argument in the court. Rule number 5 says that an advocate should appear to the court in the prescribed dress code. Like they have to wear the band, they have to wear their coat, black color gown, the black color coat, white color shirt. So whatever is the prescribed dress, so the advocate have to appear in the court in the prescribed dress. Rule number 6 says that if any member of the court who is related, like if the judge and the advocate, they have a relationship of father, mother, brother, sister, son, grandfather, grandson, uncle, aunt, nephew, cousin, husband, wife, daughter, so they could have any relationship. So this relationship should not be brought inside the court. So when they are representing in the court, they have to represent as an advocate and as a judge. The relationship, the family relationship should not be brought inside the court. Rule number 7 says that an advocate is not allowed to wear the band or the gown, the prescribed dress code which they have to wear while representing in the court. So this dress they cannot wear outside the court. So this dress code they have to maintain and wear only in the court, and in some ceremonial occasions which the Bar Council of India permits, only in such occasion they can wear this particular prescribed dress. Other than this, they cannot wear the gown or coat in any public places. Rule number 8 says that an advocate shall not appear in or before any court or tribunal or any authority or against any organization or any institution, society or corporation if he is a member of the executive committee of such organization or institution or society or the corporation. The executive committee, by whatever name it may be called, shall include any committee or body of person which for the time being is vested with the general management of the affairs of the organization or institution, society or the corporation. So if an advocate is pecuniarily interested in a particular case, so in such case an advocate shall not act or plead in such cases. So this is said in rule number 9. Rule number 10 says that an advocate cannot be a surety or he cannot certify the soundness of his client for any illegal proceedings. It is the duty of an advocate to cooperate with the bench. To achieve good result in administration of justice, there must be good relationship and cooperation between the bench and the bar. This is the fundamental principle of bar-bench relationship. It is the duty of an advocate to perform his function in such a manner that due to his act, the honor, the dignity and the integrity of the court shall not be affected. An advocate is an officer of the court. He is a friend of the court. An advocate should not criticize any judicial conduct. He must not lose his temper at any unfavorable ruling or any unfavorable judgment. Boycotting has become a regular practice in schools, colleges, factories, offices, everywhere. Wherever there is a strong trade unionism, boycotting are conducted very often. It is no doubt it achieves the favorable result by this constructive bargaining power. It may achieve to fulfill their demands. Fundamentally, the principle of boycotting, whether good or bad in other field, it is a debated point to be discussed in the light of society, education and economical factor. The important question is that how far it is genuine in legal profession. An advocate shall not boycott or refuse to practice in a particular court or before a particular judge. It amounts to disrespect to the court. It destroys the public respect to the court. A lawyer who refuses to appear in a particular court or before a tribunal is against the professional ethics and etiquette. It also means that it is his professional negligence towards the court and also to his client. It is also the duty of an advocate to maintain his temper. An advocate should work seriously and peacefully. He should not use vulgar language in court. He should not be a short-tempered person. In his drafting and pleading, and also in the argument, he should not use bad language and scandalous attack. When an advocate accepts a brief, he should attend all adjournment properly. If he has any work in other court, he should first obtain the permission from the court concerned. Particularly in criminal cases, it is the first and foremost duty of an advocate to attend. While the case is going on, the advocate cannot leave the court without court's permission and without putting another man in charge. Preferably, he could be his colleague, his junior, or his friend advocate. It is the duty of an advocate to give proper advice to his client. He should not advise his client to disobey the court order or decree, howsoever it is against his client. It is the first duty of every citizen to respect the judgment of the court. If an advocate advises his client to act against a court order, it becomes a contempt of court and also against the professional ethics. If there is any grievance against the judgment, there are opportunities still by way of appeal to the superior court. I hope, friends, that now it is clear to you that what are the duties of an advocate to the court. I'll meet you in the next video with a new topic. Until then, this is me, Nakshatra, signing off.